Okay, lunch is on the horizon. I am pleased to introduce Mr. Paul Goeringer. I'm sure you've heard of this guy, a senior faculty specialist and extension legal specialist at the University of Maryland with a string of credentials like BS, MS, LLM, JD, all those fun things. Ag Law. Paul brings a wealth of experience and knowledge in agriculture law to our discussion today. Many may not know he was raised on a wheat and cattle operation in western Oklahoma. He brings an genuine understanding of the industry to his work. A graduate in Ag Econ from OSU, a JD from University of Oklahoma, Paul's dedication to agriculture law in Maryland is evident. I also want to acknowledge his commitment to teaching, mentoring, and supporting undergraduate and law students, part of the reason I'm here today. And as he does annually, Paul will enlighten us today with his presentation, 2023 Ag and Environmental Review, and what to look out for in 2024. Rumor has it there might be a few memes or GIFs sprinkled throughout to keep you awake till lunch. Please join me in welcoming Mr. Paul Goeringer, whose insights promise to enrich our understanding of the future landscape in agriculture and environmental law.
Cool. Give me 1 second while I get set up, because I am the person monitoring Zoom, so I need to make sure I can see the questions if any come up at some point. Before I get started, everybody look in the back of your name tag. Flip your name tag around. You have a colorful ticket in the back. Pull that colorful ticket out. If you do not have a colorful ticket in the back, please go out to the front and see registration, and they will help you get your lunch options selected. They will be coming through about 11:45 to clean the tables off and kind of set some places on them, so be prepared for people to be out here shortly, but have the tickets out because that will help them place the lunches. I have now done my housekeeping step, and I need to make sure I keep my ticket so I can get my lunch later. Okay, so yes. I am well, I guess I'm not the only thing. For the first time in many presentations over the past week, I've done about 12 presentations. I am not the person standing between you and lunch. It's someone else. So I cannot waste a lot of time as I do this. But we have a lot to talk about. Let's see if I can get this going. None of this is legal advice. I hit the record button earlier, so we're all good with that. And at some point, I'll remember to get rid of the software update on my laptop so none of you have to see that the rest of the day. Probably make your viewing pleasure better. So let's talk about what we're going to talk about. We're going to talk a lot about the cases that I have been following over the past year related to ag and the environment. We're going to talk about who came to talk about constitutional law today. Let's be honest. I knew Doug would be here to talk about constitutional law. We're going to talk about environmental law. Who's here to talk about patent law? Some of you are here. Pesticides and right to farm cases. So let's move on. Oh yeah, keep in mind, as I keep pointing out to groups, as I've done this a couple of times, these are just my thoughts. Does anyone know what I would be doing if I was able to tell what the future was? Wasn't there a $2 billion lottery recently? I would have won that if I could tell the future, so we'll play that off. How many people have heard of Prop 12? I gave this presentation the other day in front of a bunch of nutrient management folks and other groups, and no one had heard of Prop 12. So I was like, okay, we have to start at the basics as to what Prop 12 is. But for those that want to know what Prop 12 is, it was passed in 2018 by California voters. It covered basically how pork and eggs and some other products would be raised and how it would be sold, meeting those standards within the state of California. The idea is we were limiting gestation crates and battery cages for eggs. Just so everyone is aware as we get started, where does most of California's egg and pork production come from? Not California. So this was seen as a burden upon basically producers in Iowa, North Carolina, Illinois. Where else are eggs and hogs grown in this country in large quantities? That's the states that were going to have the impacts on that. These states claim, or not these states, these growers claim that this law violated the Dormant Commerce Clause. We're going to talk about that here in a second, my basic understanding of the Dormant Commerce Clause. Mind you, I'm a person who went to school and learned ag law, not constitutional law. And I haven't taken that many constitutional law classes since I graduated law school a few years ago. So the Commerce Clause is in the Constitution. It's in Article 1. If the law students in the room can tell me which section it is, there are no bonus points for you, but you probably know which section of Article 1 it is in. That is the article that deals with Congress. It says Congress shall have the power to make laws to regulate trade among the states, the foreign nations, and the several Indian nations, if I remember correctly. The Dormant Commerce Clause is an idea read into this. It is being created by the Supreme Court. The idea within it is states can't set rules that discriminate against international trade, or not international trade, trade amongst the states, interstate trade. Because if we do that, what happens? I did not include a GIF of this. How many people have seen Ghostbusters? This is dogs and cats living together. It's mass hysteria because all states would start discriminating against each other if we could. Because we believe our products are the best grown in our state, right? So we want only those that came up. No federal court agreed with these groups leading up to this, and they tried various different suits in this. First, the state's attorney generals brought a lawsuit from these ag states claiming this violated the Dormant Commerce Clause. Federal courts rejected that, saying they were not the parties to bring the litigation. The U.S. Supreme Court heard this case last year. And justice sided with ag groups. I'm an interactive presenter. Does anybody know why justice intervened in this case? The U.S. Justice Department. If this case were upheld by the Supreme Court, it would create a lot more problems than that. And just from reading some of the Supreme Court opinions on this and listening to some of the advocates with it, there are some interesting viewpoints by some of the justices in this case that we're not going to get into today. So this is a fractured opinion. It's a 5-4 decision in the end upholding Prop 12. They basically said there wasn't enough to show discriminatory effect within that. Within this, the whole opinion that was written by Justice Gorsuch did not get a majority vote. There's actually a Maryland case cited in this opinion, for those that have read the opinion. How many people know that we have a law that talks about how gas stations can be in this state that the Supreme Court has upheld? I learned that as a part of this. I had forgotten about that case from law school. There's a lot of stuff that went on in this. The dissenting justices said there was enough basically to show substantial burden on interstate commerce from this. If you look at the opinions and you look at the concurrences within this, and in a couple of cases there are concurrent/dissent depending on what they did. If you flipped Coney Barrett and Kagan, if I remember correctly, I believe it's Coney Barrett and Kagan, not Coney Barrett, not Coney, the most recent one, Jackson Brown. Jackson Brown and Kagan, you would have had a different outcome in this case. They almost saw substantial burden, but they wanted to see a little bit more within that. Gorsuch and Scalia kind of led the way, not Scalia, Scalia's long since left us. Gorsuch and Thomas kind of had this view within this. They don't believe the Dormant Commerce Clause exists within the Commerce Clause. They were joined by liberal justices who did not see this as having enough. The 4 votes were conservative justices, so this may have been upheld or not upheld if we had just flipped a couple of votes. So for right now, that decision is standing. We have not seen some of the outcomes that were expected based on this with states passing similar laws. I think I have this on the next slide. I do not have this on the next slide. So what we had seen and what had been litigated and considered within this is the law students in the room know of the parade of horribles, correct? That if you do something, all the horrible things that could happen out of this. One of the ideas that was potentially put into this is states could start putting additional labor requirements in to make sure that products coming into their states met labor requirements that may not be in there. So if we think about it, if products are being developed in the South, what might they not have? Access to health care is a part of that, a living wage being paid to employees. So it was seen as a way to increase worker standards. There were a lot of moral issues that were viewed as being a part of this as well. That has not happened yet, so we'll have to see what happens because this has only really been standing for about 6 months now. Okay. Who wants to talk about the general CAFO permit in Maryland and air quality? Well, John does. He seemed very energetic in the back. Oh, I went too far. Let me go back. In March of 2020, we had a Montgomery County Circuit Court in Maryland. I always put that in just because sometimes I do this in other states and they don't know where Montgomery County is or what state I'm even talking about. Upheld that the state, through MDE, through the general CAFO permit, needs to take into account air emissions as a part of CAFO or the AFOs. First question, what did I just say we needed to take into account with a water quality permit? Air emissions. We have other laws on the books that potentially regulate this. They base this around this word admit within the statute. You may have seen these slides before. I reused them so we could refresh everyone's memory as to what we talked about the last time I talked about this. The court agreed with arguments braced by the environmental groups that the ammonia from the exhaust fans would eventually come out and hit covered waters under the Clean Water Act and state water quality laws. So what does that mean? I took out the slide where I had in here. Basically, EPA's viewpoint of this is non-point source pollution, because once it comes out of the point source, goes up into the air, it's coming back down as a non-point source pollution. We've learned a lot about air quality and how air works through some of this in looking at this opinion. The Maryland Supreme Court reversed this over the summer. In fact, I put together, and this is a plug for anyone in the room, for the Scholars program that empowered us, a program last summer where we looked at this court opinion, and it started out in May, and we thought we would have an opinion sometime over the summer. And Emily, when did we get the opinion? Like the last week of your internship? Yeah, so we spent the entire summer anticipating, thinking about how this would work. And then we never got the opinion till the end. But we came up with a lot of good ideas out of that we can talk about later when I'm not up here presenting. The Maryland Supreme Court reversed this decision. First question for those in the room, how many AFOs are in Montgomery County, Maryland? And a few people may know this. 600, but there are no poultry facilities, which this was geared towards. They were called out in this for forum shopping by the Supreme Court in bringing it in a venue that had no poultry facilities that would be on notice that this was happening. So that was the first thing that happened. They pointed out this needed to be brought somewhere where there were poultry facilities. If your arguments were geared towards poultry, they needed to be brought by poultry. In their defense, it is a general permit of general applicability, and you can bring it before, and Tom can refresh me if I'm wrong, any circuit court within the state of Maryland that has jurisdiction over the permit. So they took it in the right spot. They just kind of hid where it was happening. The court upheld the permit by MDE because they had technology limitations already in place to help reduce some of these air emissions. At least that's what I'm reading from when I read the opinion. They took into account ammonia regulations based on this within that permit, and it complied with all the laws it needed to comply with. So it's been upheld. I'm gonna get a drink. For those that don't know, I love right to farm laws. Right to farm laws are general nuisance defenses for farms. As long as you meet the requirements, you get the defense of the law. So you cannot be found a nuisance in court. For the first time ever in my 11 years in this state, we actually had an opinion involving a Maryland farm on the Eastern Shore. So with that, Maryland's law operates differently than all other states operate. So us and New York are the only two laws that operate in this fashion. With Maryland's law, in all other states, you go to court. If you qualify for the defense of the law, you go to court, you prove the law applies, you get out of court. What happens if you go to court with the attorneys and the law students in the room? Who still gets paid? Attorneys. We like to get paid. We like to get money in the end because we have offices to keep up and other stuff. Maryland's, you go through mediation. You automatically, if you qualify and it's a nuisance suit, you go through mediation through the state's ag mediation program, through MDA, or you go before a county ag reconciliation board that a number of counties have adopted. These typically are made up of local farmers. The ag educator in the county sets an ex officio member. I believe sometimes USDA is a part of it, NRCS is a part of it. Realtors, county officials are a part of it. They're made up differently. The idea is they hear the case the same way. They're supposed to help mediate a decision and help prevent going to court. In a lot of cases, they reach out to the mediation program, have them do it. That did not happen in what I'm about to talk about, is my understanding. So the operator in this question buys the farmland in 2020. Sometime in 2021, we don't know when based on the record because it's not entirely clear, the operator begins to apply and store biosolids, at least that's what I'm understanding, on the farmland in this. And at some point, the neighbors start to complain late in the fall of 2021. The reason this timeline is important is in all right to farm laws, there's typically a 1-year period that you need to be in compliance with the law to get the qualifications for the law. So you have to be established for 1 year. And if you meet all the requirements, you're automatically exempt from nuisance lawsuits. How many people in the room have heard of statute of limitations? Have you ever heard of a statute of repose? Have the law students heard of statute of reposes? This is the exact opposite of a statute of limitations. A statute of limitations starts, whenever you discover that you have a case, that's when the statute of limitations starts to run. Statute of repose starts the moment that operation is established till the end of that date. We don't care if the neighbors ever figure out they have a lawsuit on their hands. They had 1 year to bring it. So that's why this timeline is important. Because if it's by March that all this happens and all this starts to come into play, we potentially have the potentially have the 1 year period in Maryland law kicking in. If this works. I got sent a video of all the bugs that were on the property when it happened after the application. So that's them flying up. I have more stories on this, but I'm not going to talk about them since I'm being recorded. We can talk later. The county board found that the right to farm law applied. But because it was before a county board that's a governmental agency, a circuit court can review that agency decision on administrative appeal. So that's what happened in this case. So the administrative agency reversed, or the decision was reversed, because they found that law did not apply in this case. Well, they found the 1 year provision had not been met in this case. The law still applied. The 1 year provision had not. They didn't look at if ag was taking place on the land before it was bought. They looked at when that farmer in question bought the land and started the practice. So instead of looking at the operation as a whole, we now look in the state at a 1 year period of when you bought the land, what did you start doing on it within that 1 year period? That's a little different than other states. Most states look at the operation. So we have a little bit of an issue here where we're a little bit in conflict with states, but it may work for the state depending on what we want to do. It's currently under appeal with the Court of Appeals. I have ways that could potentially make this better, but I have a limited amount of time, so I'm just going to keep going on with my next court case. I have more right to farm cases. And as I've asked people in other sessions before, would you like the G version of this or the PG version of this? The PG? I want to ask, I did it the other day and asked for the PG-13 and no one voted for that. They all voted for the PG version. This is now my favorite right to farm case to teach people with. And it happened just this year. It happened in August of this year. It's out of Kansas. And I'm going to explain the differences between Kansas law and Maryland law here in a second. In this situation, we have a hog farm that's being built that needs to apply nutrients somewhere. This hog farm owner did the smartest thing possible. He realized he had cropland a little bit further away that he could haul this effluent to, pipe it on it, put it on with irrigation equipment over his cropland. To do this, he had to cross 2 properties to get there. One neighbor specifically told him, in fact, the neighbor right next door to the crop field where this neighbor's house was located said specifically, please do not do this. you have property further down the road, please go put it down there. If you're the neighbor, what would you have, if you're the farmer, what would you have done in that situation? I would have moved to the other spot. He just Leroy Jenkins it and said, let's go here, and continue to move down to that spot. So he did what he wanted to do. He then went to the county to get a permit, because to get a permit to lay the pipe he needed to do, he needed a permit from the county commissioners to do this. The record's a little unclear on what he did when he went to the county commissioners. It starts off, he flat out lied to the county commissioners and said he had his neighbor's approval to do this. They figured this out, then sort of rescinded some of the stuff they did in all of this. Now, how many people know how roadway right-of-ways work outside of Maryland? Say in central US. So with roadway right-of-ways, and this was along a county roadway right-of-way, the county has a right-of-way over the property for a road for general transportation purposes of the public. You can lay certain things that are for the public along that, like power lines, utility lines, gas lines, stuff like this. He tried to put his pipeline in the county right-of-way, destroyed a fence of the neighbor that didn't want him to put it there, his property, in the first case, and then decided within all of that, when the sheriff showed up to tell him to stop doing this because he didn't have permission, he said, I don't need permission to do this, and then left for the day and came back the next day and finished. As somebody with the Kansas Department of Ag has pointed out to me, how many people have seen Parks and Rec? This man is Ron Swanson. He didn't need a permit. He could just do whatever he wanted to do. He got everything put up, started it running. He oversprayed every time and hit the neighbor's house who complained. The neighbor's house was so impacted by this, the neighbor who lived in Kansas had to move to a second home in Nebraska. I still have questions as to why you go from Kansas to Nebraska with a second home, but we'll not go down that road hole because he's not here today to answer those questions. The other thing that happened with this is this neighbor wanted to sell. He was looking to retire, wanted to sell to a local farmer to take over the property. The sale fell through because of the smell associated with this. His house became no longer habitable. In fact, at many times when the wife of the neighbor was walking outside, she was hit by the effluent. By the way, none of this is illegal under state law there in anything. At the time, the Kansas law requires you to be in compliance with all applicable federal, state, and local laws, regulations, and permits. Maryland's is slightly different. It just requires you to be in compliance with ones that relate to the operation. This is fairly broad. For the law students in the room, anybody want to guess what he has violated at any point by doing this? Has he committed a trespass at any point by doing this? Yeah, he's committed trespass. More on that in a second. So he's in compliance with all the applicable laws, does everything. The neighbors sue for nuisance, along with a whole host of other issues. There's more on why I think this is a great case. So he just pointed out trespass is a tort claim. Trespass is a law. He committed trespass to get there. Can you do that as a part of the nuisance? The Kansas court said, yeah, if you trespass to create the nuisance, you don't get the defense of the law. So he had to be in compliance with all the laws, including tort law, just to get the defense. This is why this is my favorite case now to teach. Once he was sued, do you cut back on the number of days you spray or do you double down? He doubled down. They documented this. From the moment the lawsuit started to the moment it went to jury trial, he sprayed twice as many days as he had the year before. When he lost at trial before it was appealed, would you just stop at that point and walk away and take your lump and do it? No, he didn't. He did the most impressive thing ever. He loaded a truck up with effluent and parked it outside the neighbor's house and let it sit there for 2 weeks. On appeal, the Court of Appeals looks at the record and includes that and goes, we are willing to uphold all of the punitive damages against you because you are a horrible person. Like all of this, like in the end, as I keep telling people, don't be a jerk. If you're sued, don't be a jerk. That's the best way that you're gonna lose in court. All of us that file right to farm law cases looked at this court opinion and we started reading it. We looked and said, if this guy wins, this is awful for right to farm laws because this guy does not deserve the defense. This guy deserves something else. And luckily he's lost. I've since talked to people in Kansas who says he believes no laws should exist and like there are other fun things about this guy. So he seems like a winner all around. And then finally, I guess I have a few more things to do. Oh good, I'm doing good on time. I have 15 minutes left. So how many people remember back when Roundup Ready technology came on and all the lawsuits Monsanto at the time litigated with people saving seed and saw all that happen? That kind of ended in 2014 when the Roundup Ready technology patent expired. Well, since then, Bayer, that now owns Monsanto, if my memory is correct, when I put these slides together yesterday, Bayer released the XtendiMax technology that includes Roundup resistance and dicamba resistance. Those came on the market in 2016. For those that followed this, what happened in 2016, 17, and 18? How much drift damage did we have as people took this on the market and started utilizing it? We had a lot of drift damage that happened during that period of time. Bayer ended up settling for a few $100 million with all the growers that experienced, drift damage. Some Maryland producers may have gotten some checks cut to them because of this, as long as they could document it and prove it. They had that going on. But since this technology has been released, and my shout out to Bloomberg News for making me aware of these cases being out there. I had not seen them yet. They reached out to me in March to talk about them, and I'll explain where the thoughts I had here in a second as we go along. So this new technology included over-the dicambas that were approved by EPA for over-the-top applications, but did not include the older variations of dicamba in all of this. For those that deal with dicamba, what happens with dicamba if we spray it and certain weather conditions exist at the time? Can it drift? These newer varieties were not supposed to drift as much. There were still some drift issues with them, as the lawsuits kind of prove. So Bayer has begun this year. There's about 10 cases filed in the US. They're all filed in the Eastern District of Missouri. Any guess as to why the Eastern District of Missouri? Where's Monsanto located? St. Louis, Missouri. When you sign the tech agreement, you agree to be sued in St. Louis, Missouri. So they have filed these. They are all patent infringement cases for growers who they can show save seed, because that is in violation of not only US patent law, but it's in violation of the tech agreement they all signed to do this. The other thing to point out with this is, when can you save seed legally in the US with what kind of seeds? Those with the patent has expired, or those that are produced under the Plant Variety Protection Act, because that does have a save seed function. We don't see many seeds like that in some areas anymore. We see them particularly in other areas, not so much with corn and soybeans anymore. And this is much more focused in on corn or soybeans and cotton than anything else right now. Here's the twist. With a few of these, they're not only claiming you violated the patent by saving seed, they're claiming you violated the patent by either spraying unapproved dicambas over the top or by spraying past the EPA approved dates. Where they can prove this, they are bringing this in the litigation. Anyone want to guess why they're doing that? Because I'm going to talk about why here in a second, but anyone want to take a guess? If you just got hammered in a class action lawsuit because your tech people allegedly told everybody that they could spray any kind of dicamba they wanted to, which was what part of the record was in the class action litigation, you probably want to protect yourself if this happens again. So yeah, in 2020, they settled the drift litigation, or the class action drift cases. My thought has been, as I talked to a couple of reporters on this earlier in the year, as they were trying to figure it out, they thought they were just looking at Bayer bringing back patent infringement cases. And I was like, no, this is actually the bigger issue in this. I think they're bringing this because they need cover if they get hit again with a class action litigation. They need to be able to go to court and say, look, we are actively enforcing our patent and we are trying to prevent growers from doing this. We just have bad actors out there who don't understand what they're supposed to do, or they're cutting costs. We are actively going after them, so please leave us alone and sue somebody else, not us. I think I've got to have enough time, and I should have some questions to take at the end of this. I'm not even going to try to pronounce that pesticide because I always screw up saying it. The 8th Circuit reversed EPA's decision to ban it. When the 9th Circuit came and looked at the regulations a few years ago, they gave EPA a choice. They could either go back in, redo everything to meet what the court required, or fix it, or just ban it all out. EPA took the easy approach. They just banned it. So now the court's saying you need to actually go back and develop an administrative record to show that was actually the decision you should have reached. Held versus the state of Montana. Basically, the Montana court ruled that the state's clean energy policies violated the rights of a clean and healthy environment under the Montana Constitution. That one's a big deal because with a lot of climate change litigation, and I have a few students working on climate change stuff as a part of a Hughes Center project, we've been having trouble figuring out how some of this would play out in court because federal law doesn't really allow it, but we're looking at a lot of the state courts. This one's just from a few weeks ago, so I thought I'd include it to make it slightly more interesting. USDA has announced the final rule for transparency in poultry growing contracts and the tournaments. They will have 75 days once it's finally printed. It has not gone to print yet. I can't find it in the Federal Register, so I don't know what that 75-day period is going to be. So at this point, we're still looking as to what that will be. I'm working on trying to get that reviewed, but I have not been in my office in about 2.5 weeks. So at some point, I'm going to work on it. I'm working on it with an ag economist out of Auburn to try to put together some materials on that for folks so they can better understand it and better make comments as it goes through the process. And then we also still have moving forward a bunch of litigation in the South where former growers are suing their integrators, mainly focused in on Purdue and Sanderson Farms, saying they are actually not independent contractors. They were employees and they were not paid minimum wage under the Fair Labor Standards Act. They were owed overtime under the Fair Labor Standards Act, and they were owed some other things under a few federal laws, but it's much more pushing that they are employees and not independent contractors. My wrap up is I grab a drink. I only hit like the surface. I didn't talk about Clean Water Act, where Sackett really did say that Justice Kennedy's test is dead. We're no longer even going to look at it. And there's a bunch of litigation going on under what Waters of the U.S. still means under that. We've had a lot more stuff going on within the year. This is just, like I said, the surface. The interesting litigation, I still think, is going to be the Bayer litigation to watch because I'm curious how all that's going to do. I have thoughts as to how the pesticide part of that will play out, but I don't know yet. Our right to farm case will be interesting to watch as it's appealed. I participate with the Southern Extension Economists in Southern Ag Today. If you want to read me ramble on legal stuff, that usually happens a couple of times a year on Fridays, but we do legal stuff on Fridays, specialty crops, co-ops, finance, trade, policy, marketing, a whole bunch of just economic stuff that you might be interested in, and has implications to the region. They've been pretty good at including us in stuff that happens on there. I do a blog at agris.umd.edu. What questions do folks have with my remaining 10 minutes? We can play Stump the Chump. I bored you all to death. I should look for online since I have it. Yep. I can remember how to work this. And that QR code may or may not work. They have not sent me a more recently updated one. And if our online people would like to put questions in, I have the question box up front and I can see. And I'll read the questions off. Yes, sir. That was the one I was talking about. That was the court case. Yeah. Yeah. I didn't use the county name. I was trying to protect Talbot County in that.
Other questions? Hearing none, I guess we're done.
And then I need to turn it over to Megan, I believe, to introduce the next speaker. Thank you, guys.